Hello students, good evening. In this session, we are going to discuss a very important topic in Indian polity, that is Indian polity, the historical background of the Indian Constitution, an extremely important area. Now, basically, what are we going to know about the historical background and evolution go together, but I will take another session on evolution. From today onwards, every day at 9 o'clock, I'll be live. I am going to take one topic a day in polity, couple of days on society, couple of days on ethics. So today's topic, Indian historical background, is basically related to the impact of laws enacted by the Britishers during British rule on Indian Constitution. British rule on Indian Constitution. A very, very important topic. This topic actually overlaps with your Indian history. In modern Indian history, also, you have this topic. However, the difference between modern Indian history, constitutional development in India, and historical background here is in modern Indian history, you just don't read the law. You also read what led to the enactment of the law and what was the impact of the law. So, you read the cause and effect of the law along with the provisions of the law. But here we only talk about the provisions of the law, as in how did they impact the making of the constitution. Remember, Britishers had enacted several laws when they were governing India, and these laws had a profound impact on Indian constitution, most importantly in two spheres. One is the federal structure of India, the other is parliamentary form of government. As we all know, though Britain is a unitary form of government, it provided for a federal form of government in India. And later on, we adopted the same federal form of government in India. Likewise, parliamentary form of government owes its origin to the British rule in India, because Britishers introduced parliamentary form of government in India. And please remember that the British Parliament is known as mother of all parliaments. Now, the introduction was done in India through the British made laws. Now, what are these laws and how did they affect? A very quick backgrounder, I'm going to tell you. See, the focus of this session will be on quickly telling you what all is important for you in the laws that were enacted. Regulating Act 1773 is the first legislation that was enacted for India. This was not enacted directly for India. It was enacted to regulate the affairs of the East India Company in India. So it is very important law. Three major things that we have to know about this. But before that, please remember, in historical background, we talk about two phases. That is the company rule, the laws enacted by the British Parliament when East India Company was ruling India. This phase roughly starts in 1765 and ends in 1858, and then we talk about the crown rule. Crown rule basically started in 1858 after the 1857 revolt and ended with the 1947 India Independence Act. So the most important feature of these two phases is, while this provided for centralized rule, this provided for decentralized rule. Crown rule was marked with decentralization, which eventually led to the establishment of federal form of government. Okay. Now, the other benefit of this particular class will be, I'm going to explain all the laws in the form of a flow chart. The more flowcharts you read, easier for you, because flowcharts help you to quickly revise. So let's begin with the Regulating Act 1773. As I said, first legislation made by the British Parliament to regulate the affairs of the East India Company. From polity perspective, it is important for three reasons. The first reason is, see, when Regulating Act 1773 was enacted, we had three presidencies in India. One was called as the Madras Presidency, Bombay Presidency, and Calcutta Presidency. And each presidency had its own governor. Now, what they did is, they said Calcutta's governor will be designated as Governor General of Calcutta, Governor General, and the governors of Madras and Bombay, will continue to be the governors. So, they subordinated the governors of Madras and Bombay to Governor General. Governor General will be the governor of Bengal was designated as Governor General, and these two governors were subordinated. So, this marked the beginning of centralized rule in India. The second major change this brought in was it established the Supreme Court of India. In 1774, the Supreme Court of India was established in Calcutta. And please remember, this is very, very important. When we talk about origin of Indian judiciary, we make it a point to mention. And remember, it had 1 plus 3 judges. One Chief Justice and 3 judges were there in the Supreme Court. The third very important change it brought in is the Governor General was now assisted by an Executive Council. So it provided for an Executive Council to Governor General to aid and advise him. Today, we find similar precedents in the Constitution, similar practice in the Constitution in the form of Council of Ministers to aid and advise the President, Council of Ministers to aid and advise the Governor at the state level. So these were the three major changes that took place with the 1773 law. The Act of Settlement of 1781 was basically an amendment made to the 1773 law, but why was it called as the Act of Settlement? The reason being that this act was basically enacted to settle a dispute between two very important entities of power. One was the Supreme Court, the other was the Governor General. So, primarily, it wanted to clearly define the jurisdiction of Supreme Court and Governor General. But what is more important for us is we all know that Britishers had a non-interference policy into the socio-cultural elements of Indian society, meaning that they followed a policy of non-interference into the cultural aspects. That began with this Act of Settlement, marked the beginning of policy of non-interference of the Britishers in the cultural practices of India into the cultural practices of India. Very, 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 very important. This is the only important point according to me from polity perspective. Now moving forward, the reason why again it is important is, see, government not interfering with cultural practices is a symbol of secularism. Secularism talks about non-interference. Religion does not interfere with government. Government will not interfere with religion. Moving forward, Pitt's India Act of 1784 was basically proposed by a person called William Pitts, named after him. Most important point, only point that is important is the East India Company entered India as a trading body. First, it started as a trading body, so it had commercial functions. Eventually, it started administrating India, so it also started administration. Now, what they did is they clearly divided East India Company functions into two: commercial functions and political functions. This was related to trade. They said there will be a board court of directors for commercial functions, and there will be a board of control for political functions. So, from polity perspective, the relevance of this law is, for the first time, it provided for a division of work. The first form of division of work happened with the Pitt's India Act, though not in terms of legislature executive, but the idea of dividing work happened in Pitt's India Act 1784. Now, moving forward, amending Act of 1786 is important for only one reason. It introduced the idea of veto powers. It gave veto powers to the Governor General. So it introduced veto powers. Today in the Indian Constitution, veto powers are given to the President and the Governor. Now moving forward, Charter Act of 1883, a very, very important legislation. Now this legislation is very, very important because it marked a major step towards a centralized rule in India. How? It designated the Governor General of Bengal as Governor General of India, and it removed the legislative powers of Bombay and Madras presidencies. So with this, it was like a major leap towards a centralized rule in India. 1883 is very, very important for this and very important for another reason. An attempt to introduce open competition in civil services, open competition in civil services was made, but the attempt was not successful. Finally, the attempt became successful in 1853. That is the next law that we are going to discuss. In between, there will be an 1813 Act that we are not going to discuss because from polity perspective, it does not have a lot of relevance. Now, moving forward, what does the 1883 law say? Basically, 1883 law introduced open competition in civil services. Very, very important. And more important than this is first time we have seen introduction of separation of powers. What they did is within the Governor General's Executive Council, they said there will be, they divided it into Executive Council and Legislative Council. So the first time executive functions and legislative functions were separated. Another way of looking at it is for the first time legislature or legislation was recognized as a separate function. So for the which act recognized legislation or lawmaking as separate function, recognized as separate function. Okay, these are the most important legislations that were made during the company rule. Now, what happened is we had the 1857 revolt. The British Parliament was looking for a chance to take over the power from East India Company and directly rule India. And the 1857 revolt gave them a golden opportunity to do this. Now, what did the 1857 revolt do to India? 1857 revolt ensured that there was a transfer of power from the company to the crown. So basically, this Government of India Act 1858, the primary purpose was to transfer power, the governance in India, rule in India from company to crown. Now, what do I mean by this? In place of company, earlier what was happening was the British Parliament was regulating the company and in turn regulating India. It was indirect. Now it is direct. It will happen in the name of the crown, but actually ruled by the British Parliament. The British Parliament in ruling India would be assisted by a Secretary of State. This Secretary of State has his office in London and he has a 15-member team assisting him. In India, his representative would be the Viceroy. And who was the Viceroy? The then Governor General was designated as Viceroy. Governor General of India became Viceroy. So basically what happened is Government of India Act 1858 did not change anything at the ground level. Nothing changed at the ground level. How we were ruled did not change. Who was ruling us changed. So please remember the relevance of this law is who rules India underwent a change. Okay, but how India is ruled, there is no substantial change in how India is ruled. So there was no change on the ground level. The change happened at the higher level where the power shifted hands. This is the Government of India Act 1858. Now, 1861 is very, very important because it marked the beginning of decentralization of power in India. And eventually, this decentralization paved way for federal form of government. Now, the question is, how did it decentralize? It restored the legislative powers of Madras and Bombay presidencies. This was the change it brought in. And then from here on, you see direct um, gradual introduction of parliamentary form of government, the features of parliamentary form of government in India. Why? Because 1861 law introduced the portfolio system. Portfolio system is a very, very important feature of parliamentary form of government anywhere in the world. Ministries, we say portfolios. Portfolio system was introduced for the first time. It also introduced ordinance making power. And please remember, for the first time, Indians were associated with the Governor General's Council, with Governor General's Legislative Council. For the first time, Indians became a part of the governance. So these are the most important things according to me. This is very, very important because questions on this, especially MCQs, can be asked like this. They will ask you, which of the following laws enacted by the British introduced features of parliamentary form of government in India? From 1861 till 1935, all of them introduced features of parliamentary form of government in India. Please remember 1861, 1892, 1909, 1919, 1935. All five legislations introduced features of parliamentary form of government in India. So this is about the India Councils Act 1861. Now, what did the India Councils Act 1892 do? First thing it did is it introduced the system of nomination, indirect elections. For example, you have a chamber of commerce. They could elect a member to the legislature. But please remember, elections nowhere mentioned in this law, not mentioned in this law. Nowhere do you find the term mentioned in this. Whereas the second important point you have to know about it is related to parliamentary form of government. Now, what related to parliamentary form of government was introduced? It allowed a discussion on budget, and executive could question, sorry, legislature could raise questions the to the executive. See, legislature questioning the executive, discussing the budget, approving the budget, asking supplementary questions, making membership of ministers compulsory in parliament. All these are features of parliamentary form of government. So this is a feature of parliamentary form of government. The next legislation is very, very important, very famously known as the Minto-Morley reforms. Very important for one of the most crucial steps that the British have taken, that we talk about whenever we talk about communalism in India, and that is the introduction of communal award. So most important change, sorry, not communal award, communal electorate. The most important change it brought in is it introduced the communal electorate. And the second change is related to parliamentary form of government. It allowed supplementary questions to be asked. Supplementary question, a question which you raise on an answer given by a person. So you ask me a question, I answer it. Again, you raise a question on the answer I have given. That is called a supplementary question. Now, what is communal electorate vis-a-vis communal award? Communal award was declared in 1932 by the then Prime Minister of Britain, Ramsay MacDonnell. This came into being in 1909. So this was introduced by Lord Minto. Lord Minto is known as the father of communal electorate in India, whereas communal award was announced by Ramsay MacDonnell. Now, what is the difference? Communal electorate is an election system where you grant the right to vote on the basis of religion. Only a people belonging to a particular religion will contest the elections, and only people belonging to that religion will cast their vote. This is called as communal electorate. Whereas communal award was an extension of communal electorate to other sections, other downtrodden sections of society in India, especially the scheduled castes. So this is more of a policy extension, whereas this is more of an election, a voting system, you can say. Communal electorate was initially granted to Muslims. In 1919 law, it was extended to several other communities like the Christians, the Sikhs, the Anglo-Indians, and so on and so forth. 1932 communal award was basically related to the scheduled caste, and communal award, the declaration of communal award is an important historic event in India, especially in modern Indian history, because it paved the way for a fast on to death by Gandhiji and eventually led to the signing of the Pune Pact. So these were the changes made by the 1909 law. Now, what about the 1919 Act? 1919 Act basically strengthened provincial autonomy. How did it strengthen the provincial autonomy? It ensured that the subjects of governance were divided into two lists. One was called as the central list or the federal list. The other was called as the provincial list. So the first time division of subjects happened in the Government of India Act 1919, but it was only into two lists, not into three lists. So this happened in 1919, and 1919 introduced a concept called diarchy. I'm sure you all must have heard of it. It is also called as dual rule. Now, what do you mean by this? I'll explain it in a simple flowchart. Every province, it was introduced at the provincial level. So at provincial level, you had Governor General, governor as the head, okay, and governor had two major groups assisting him. One was the executive council, the other is the legislative council. Now the provincial subjects were again divided into two parts. The subjects were divided into reserved list and transferred list. So at the provincial level, if I have to complete this flowchart, it was divided into reserved list and transferred list. Now, what happens in dual rule is governor in with his executive council will take decisions on reserved list. Governor with his legislative council will take decisions on transferred list. Within one government, you have two different entities with a common head performing two functions. This is called as dual rule or diarchy. I repeat, it is a single government, it has a single head, but it has two groups. The head with one group will act on some subjects, the head with another group will act on some subjects. This arrangement is called as diarchy. Diarchy is very, very important. Diarchy was introduced at the provincial level, but it was a disastrous failure. And in civil services, they've asked questions like what was there in reserved list. Remember, all crucial aspects of governance like law and order, police, foreign affairs, land, revenue, these were given in reserved list. All other aspects of governance like local self-government, education, these things were placed in the transferred list. So this is about diarchy. Now, apart from this, what else was introduced in 1919? 1919 law basically proposed a Central Public Service Commission, which was eventually appointed in 1926. The UPSC was eventually established in 1926. Now, the last and the most important thing is 1919 Act came into force. Montagu-Chelmsford reforms came into force in 1921, and it provided for a statutory committee to review its working after 10 years, but they could not wait for 10 years because the political scenario of India was fast changing. The freedom movement was catching up. So in 1927, they appointed the Simon Commission. The appointment of the Simon Commission had a bearing, had a deep impact on the framing of the Constitution of India because it led to a protest in response to the British challenge. We had to appoint a Nehru committee. So it's all related to the evolution of the constitution. That is the relevance of 1919 Act. Finally, the most important law, a law which had profound impact on the Constitution of India. The Constitution of India is considered to be a replica of the Government of India Act 1935. Now, what did Government of India Act 1935 do to us, and how did it impact the Constitution of India? Two major points apart from the remaining. One is it introduced a federal It actually strengthened federalism in India. It ensured that the roots of federalism were very, very deep in India. How? It actually provided for an all India federation comprising the princely states and the British provinces. The fact remains that that's never came into existence. It never came into being. This is very, very important. Remember, in your MCQs, if they ask you, was it provided? The answer is yes. Was it actually implemented? The answer is no. It was never implemented. Okay. It provided for three lists called the federal list, the provincial list, and the concurrent list. The federal list had 59 subjects, provincial list 54, and concurrent list had 36 subjects. It provided for a federal court. Federal court was established in Delhi. So it provided for a federal court. It said that there will be a federal legislature, the central legislature that today we call as parliament, federal legislature, which will comprise of Her Majesty, the Queen or the Crown, represented by the Governor General, who is nothing but the Viceroy, plus one a council of states, one house that is representing the states in India, the other house of assembly that is representing the people of India. This remains council of states, but this became Lok Sabha or House of People now. So federal legislature became the central parliament post independence. All these were provided for by the Government of India Act 1935. Now, apart from this, it also made provisions related to parliamentary form of government. What provisions? Today, we know that the ministers hold office individually during the pleasure of the president. So, this idea of pleasure was introduced in the Government of India Act 1935. Likewise, compulsory membership of ministers was also provided for in Government of India, of ministers in the legislature. 6 months gap. You are not a member for more than 6 months, you cannot continue as a minister. All these features of parliamentary form of government were introduced by the Government of India Act 1935. Not just this, a lot of procedures that are followed in the parliament, like we have the joint sitting, we have the procedure of budget. All these were introduced in the Government of India Act 1935. Apart from this, important offices like Office of CAG, Office of Attorney General, these were also introduced in the Government of India Act 1935 because of the magnanimity of the law, the amount of contribution it made. We say that the Constitution of India, it is usually commented that the Constitution of India is a replica of the Government of India Act. Nearly 60% of the provisions of the Constitution of India are influenced by the 1935 Act. Why? Because Part 5, Part 6, Part 8, 9, 10, 11, 12, 13, all these parts are by and large connected to federalism in India. So almost 60% of your constitution has been influenced. There are several provisions that have been directly picked up. You look at the provisions related to Office of CAG in 1935 Act and the Constitution of India, 90% will be the same. Same applies to Attorney General. Same applies to parliamentary procedure. So a lot of things have been picked up from the Government of India Act 1935. After this, the last legislation that came into existence in India was the India Independence Act. Now, the reason why I would talk about this is, I don't know how many of you are aware, the last article, 395 article of the Constitution declares that the India Independence Act stands repealed. The Government of India Act 1935 and the India Independence Act of 1947 stands repealed. So these were the laws made by the Britishers, introduced for in India, and they had a profound impact on the making of the Constitution. In the next session, I'm going to talk about the evolution of the Constitution. When did we get this idea of having a Constitution for India? Who proposed a constituent assembly? How did constituent assembly work? Because constituent assembly contributed significantly to the success of the constitution. I believe, and I'm sure most of you would agree, that Indian constitution is one of the most successful constitutions in the world, given its diversity and vastness. And the most important reason for the success of the constitution is the way it was framed. So due credit must be given to the Constituent Assembly for framing such a successful constitution. The foundation was solid. So what did they do? How did they ensure that the Constitution of India is successful? These things I'm going to discuss in the next session. Thanks for joining me. I'm going to see you every day live at 9 o'clock. Thank you.